There we go. That was a very menacing announcement. And if you guys want to turn your cameras on or off, that's fine too. I don't make, even in live classes, I don't make people turn their cameras on. If your mother-in-law runs behind you in her bathrobe or your dog jumps up on your computer, I don't want that to become a meme that's on the internet the rest of your life. But I'm glad that y'all are here today. Just for anybody else who is not with us, this is LGLA 1351, right? Contracts. And we've had one lecture this week on analyzing contracts or the parts of a contract. And this is a pretty simple chapter. We can always get that done in an hour. But what I usually like to do this week, because we're late in the semester now, is this contract analysis exercise. And so I've picked a contract that is a real contract from the real world. And I hope you guys have had a chance to look at it already. It is, it's this one, right? This confidential settlement agreement and mutual release, assignment of copyright and non-disparagement agreement. It is between, at least on its face, it says David Dennison and Peggy Peterson. But if you read further, it got a little more complicated than that, right? This was that confidentiality agreement between Donald Trump and Stephanie Clifford, or her stage name is Stormy Daniels. If you are an absolute Trump lover or an absolute Trump hater, it is not my intent to push my politics on you. But it just so happens that Donald Trump is a prodigious litigator and a very well-known and outspoken business person. And so he just gives us a ton of examples. This is also one of those examples that my students are liable to look at. When I was in law school, one of my favorite contracts, Tom Green was the chief counsel for Dell at the time. And he brought an example of Dell's supply agreements with its chip manufacturers. And he brought a copy of someone else's supply agreement. And he used those as examples. And I thought they were fascinating. Everybody else thought that, a 300-page contract was about the driest, dumbest thing they ever wanted to see. They didn't even look at it. But I guarantee you, if he had brought the confidentiality agreement with Donald Trump and a porn star, somebody would have looked at it. So that's why I've picked this one. And at least for another year or two, I can get a little mileage out of it. But there's another reason for picking this one, besides just picking something that you guys are likely to look at. I wanted to pick a real world contract. This is not something that I have abbreviated or shortened. You can see it's about, 20 pages long or something. This is not something that I made up. It's not something that your book made up just for fiction. This is a real live contract drafted by a bunch of attorneys who were charging at least $500 an hour, maybe more. And there's no telling how long that they spent on this. This is the kind of thing you're actually liable to see in the real world. I hope you looked at it before tonight. If you did, you probably found it horribly confusing. That is also real life because, number one, this contract is horribly confusing to me, and I've been practicing contract law for 25 plus years, okay? But with that experience beyond the law, I can kind of read between the lines here and understand a little bit of where this came from and what's going on. And even then, this thing is still confusing to me. In fact, I guarantee you the lawyers who drafted this, they have some idea what they meant to do, but even they don't understand what all of this means, because this is an example of a real world contract, but it is also an example of a terribly, terribly poor contract, okay? And I hope that by the time we're finished here, I won't keep you guys too late, and I thank you for being here, so I'll try to be brief. But I hope by the time we're finished, we see that, you know what? You actually maybe did learn a little bit of something about contracts. Not only that, but if you had been a paralegal in Michael Cohn's office, that even after just one semester, if you didn't remember anything else I ever told you, it was that going back to the basics, going back to the beginning every single time is so important. And if you had done that for Michael Cohn or one of the other lawyers involved in this contract, you may have helped them make a contract that was actually enforceable. So the contract analysis exercise I gave you 12 questions. I hope you didn't I hope they weren't too confusing or you didn't spend too long slaving away on them. None of them were meant to be tricks, but my intent was to kind of try to walk you through the bigger picture. What I wanted you to do is what I did when I first read this contract was I looked at it and I started looking for the basics of a contract to see if this was even going to be enforceable. Hi, Sheila. Thanks for joining us. But what I wanted you to do was take a look through this contract and see if you thought it was enforceable. And if it got your interest and it was a little confusing and you started to dig through it a little more to see, now, wait a minute, I remember something about consideration. Is this going to be enforceable? Then I think if you answer some of these questions, it will get you, I hope, to the same conclusion that I reached. But if you got a different conclusion, that's okay too, because I guarantee you there were hundreds of thousands of dollars spent litigating this contract. And there were lawyers on both sides arguing two completely different opinions, and none of them got disbarred for being completely ridiculous. So I think the answer is clear, but you could at least make a colorable argument. We don't always get to pick our clients when they come in. If we were working in the law firm and this contract came up, I don't know whether it would have been Ms. Clifford or Mr. Trump who came in, right? We don't always get to pick our clients. And so you do have to be able to argue both sides. But let me do this. I'm going to go ahead and throw that contract back up on the screen so we can take a look at it and kind of go through this step by step. And I'll do that by asking the questions, or talking about the questions that are in that assignment. If I've got the document on the screen, I can't necessarily see if you raise your hand or something. So if you've got a question, please feel free to, or if you've got an answer, please feel free to just turn on your mics and shout it out. You can put it in the text box there, but if I've got the document up, I may not be able to see the text, okay? To start out analyzing this contract, these are not just practice questions, but these are kind of the questions I would have asked myself. And the very first one is, who are the parties to this agreement? Sounds pretty simple, but I mean, who's got an answer? Who are the parties to this agreement? That's all right. Nobody's brave enough yet. You'll get there. I guess let's start with, where are the parties to this agreement, right? In this chapter, we talked about the sections of contracts. They don't always have to be there, but they so often are. And just like your book predicted, look at this contract. The very beginning, paragraph 1.0 is titled "The Parties," right? And who does it say the parties of this agreement are? It says it's EC LLC, some company, and or, that's a little suspicious, but and or David Dennison and Peggy Peterson. So at the outset, it looks like we have at least three parties, but we've got this weird and or. So what is that about, right? Let's put a pin in the one about David Dennison, because maybe that's really where this contract, we're determining if this contract is enforceable. Maybe that's where that ends up. But it looks like the parties are at least this LLC and Peggy Peterson and David Dennison. And if those names sound strange, just to set the table for you, I will let you know that they had this agreement on the side at the same time, okay? They had the second agreement, this side letter agreement, they called it, where they identified that Peggy Peterson is really Stephanie Clifford, AKA Stormy Daniels. And David Dennison is really Donald Trump. They redacted Donald Trump's name when they filed this in the lawsuit, where they made this a public record so that everybody in the world could see it, which sounds like exactly the opposite of what they intended to do with the confidentiality agreement, right? So you got to be careful. But that's what this side agreement that's at the very end is about. It is about saying, it's really a definition, right? It's about saying that, hey, in this contract, when we say Peggy Peterson, we really mean Stephanie Clifford, who is also Stormy Daniels. And when we say David Dennison, we really mean Donald Trump. And you can do that because this is your contract. And remember, those specific definitions always control, even over the ordinary meaning of the word.
Put a little food in Parker's bowl and Sox's bowl, please. Well, just put some food. It doesn't.
There we go. Sorry about that.
Looks like they're running out. Is there?
Oh, they have some more over there.
There we go. Sorry about that. So the answer to who are the parties is pretty easy. It's in paragraph 1, and it's at least EC LLC and Peggy Peterson and or David Dennison. Okay, it's right there in the beginning. Second question is, and this was really just kind of easier and for points and to show you that this chapter really knew what it was talking about. It asked, identify which section contains the recitals, right? And that also was easy. I mean, look, they did at least a good job in drafting this contract of giving you, subsection headings and signposts, so you knew where the recitals were. And the recitals are right there in paragraph 2.0 or section 2.0 with all these second paragraphs or subparagraphs. And if you look at it, you can see what your book was talking about. What are the purposes of recitals? And you can see here that it sets the context for what's going on. That there has been some kind of relationship, or at least some kind of alleged relationship between the parties, that they want to keep the secret. They want to keep it so secret that they don't even say it's because one of them is getting ready to run for president. But they clearly, the parties clearly wish to keep this stuff confidential, and they don't want anybody talking about it. And so that is the purpose of this agreement, right? And that's what a recitals section is. It's right there in section 2.0. Pretty simple, right? So far. So we got parties and recitals right at the beginning, right where your book said they were likely to be in a real world contract. All right. Now things are going to start getting a little more difficult. If you look at question number 3, right, when we're analyzing any contract, what are the required elements, right? You have to have consideration, mutuality, legality, right? So looking for the consideration is important. Remember, for consideration and mutuality, every side has to give and get something. That's always been my definition of consideration. What you give for what you get. And unless we often think about a contract as between 2 people, but this looks like a contract potentially between 3. And that means that every party has to both give something and get something. And if there's somebody out there that doesn't both give and get something, then they're not a party, right? In fact, that may help us decide whether David Dennison is a party. Was he supposed to give something? Was he supposed to get something? I don't know. Let's go through these questions and let's look for that consideration, okay? Question number 3 is what consideration was ECLLC supposed to give? Did anybody find that? Does anybody remember? Shout it out if you remember. If you're still shy, that's okay too. 3.0, right? 3.0 is that your book suggested that some contracts would have a consideration section, right? Where they summarize the consideration. And indeed, here it is, 3.0, settlement terms. Are these the only settlement terms? Well, heck no, this entire contract is settlement terms, right? But here is at least a summary of the consideration. And 3.0.1.1.1, kind of a ridiculous way to number your system. But it's pretty clear about the consideration that ECLLC was supposed to give. They were supposed to give $130,000 in cash, right? Wired to Peggy Peterson's attorney. All right. So ECLLC was giving consideration. Were they getting consideration? Well, we can look at the rest of the contract, and that wasn't one of your questions, but I would argue they did, right? Nobody paid anything directly to ECLLC or gave anything directly to ECLLC, but ECLLC got what it wanted, which was an agreement from Peggy Peterson to keep her mouth shut, right? Who cares why they wanted it? Who cares how much that benefited them? If you remember our peppercorn, right? Even a peppercorn can be consideration. So it appears to me that they clearly gave consideration. They were supposed to give $130,000. And I believe they got consideration. They got her agreement to be quiet, right? So that's question number 3. That was pretty easy, but now they get harder. Question number 4 asks you to please summarize generally. When we talk about ECLLC, I just said what consideration was ECLLC supposed to provide? That was easy. It's $130,000. But when it came to Peggy Peterson or Stormy Daniels, I asked you to summarize it generally. Do you have any idea why? Was anybody able to figure out the consideration Stormy Daniels was supposed to provide? Don't be afraid to speak up if you've actually looked at it. But the answer is that probably none of us get that right. At least we don't get it 100% right. I've looked over this contract, 25 times, And every time I do, I've got an old dog-eared copy of it that I've used for classes, a dozen times. And every time I go through it, I end up highlighting one more thing that Peggy Peterson was supposed to do. Because there was a ton of stuff she was supposed to do, right? She was supposed to, first of all, keep her mouth shut. That's the most important, right? We can find some of these paragraphs. Right here in 3.1, undertakings and obligations by Peggy Peterson, right? She will at least do the following. She's going to execute this agreement. Then we have these weird things, like she's going to transfer rights to the property. She's going to deliver to Donald Trump existing copies of tangible property, right? What were they talking about there? Why is that? What does it even mean? Where did it come from? I can tell you what happened here based on my experience. These were lawyers who were not typically trial lawyers, and they were trying to draft a settlement agreement. But what they are was entertainment lawyers. At least one of them was an entertainment lawyer, or they worked with entertainment lawyers who were used to drafting contracts about copyrights and property interests in intellectual property, right? And so they had a settlement agreement that had likely been used, or a contract that had likely been used multiple times before. It had been cut and pasted and cut and pasted and cut and pasted. They liked it and it worked. And that's what they knew about. They knew about copyrights and intellectual property rights. And since that's what they knew about, they tried to shoehorn this agreement in to make it work for what they were doing, right? So they went around defining things like if Stormy Daniels has any photographs or recordings or emails or letters from Donald Trump, then we're going to call that the property, right? If she has any, and then they started talking about like intellectual property rights, right? Like if she has a right to her story, to make a movie out of it or write a book out of it, they called that property, right? And so they created all of these kind of intellectual property rights like they were selling an idea to a movie, because that's the kind of lawyers they were, all right? Does it work great here? I don't think so. You all can read the contract. The purpose of a contract is to clearly identify everybody's obligations and to clearly identify what would be a breach and what the penalties of a breach were. And if this is clear to any of you, then you're better lawyers than I am, okay? But that's what was going on here. So she was supposed to collect all of this property, photographs and pictures and emails and voicemails and that kind of stuff, and actually deliver it to Donald Trump so that it didn't get out there, right? That makes sense. If you're going to run for president and your alleged ex-girlfriend has a bunch of pictures of you from when you were allegedly dating while you were married, and she also happens to be a porn star, that's probably not the kind of thing that's going to help your presidential campaign, right? So of course you would want all that turned over. But the question here was what consideration was Peggy Peterson supposed to provide? And in this paragraph 3, there's a bunch. She's supposed to collect all this information. She's supposed to deliver it to him. She's going to provide to him, not only she's supposed to provide him information, but then she's supposed to summarize anybody else she's told about this relationship, or any other emails or stories or those kind of things that she might have told anybody else, presumably, so he can start rounding that up. In addition, she's supposed to provide any copies of any agreements or these kind of things. Then we have this transfer of intellectual property rights, right? She's supposed to do that so that she can't go write a book or make a movie about their relationship. But there's more. There's more. She's supposed to deliver a certain property, and there's more. In addition to this section 3 that was specifically on consideration, there's more, right? Because remember, the consideration is what you give for what you get. It's not the one thing, it's everything you were supposed to give, everything you were supposed to get. If you look at the section 4, you start having things like representations and warranties. It starts with some definitions, but look right here, 4.2, PP's representations and warranties. What is that? That's her making another enforceable promise that she's going to list everybody that she has told about this relationship. And if she leaves anybody off the list, then she has represented and warranted that that's true. So she's in breach of the agreement. Okay. So that is consideration. There's more. That she shall not be responsible. Here's more representations by Peggy Peterson or Stormy Daniels that she's not going to enter into any other kind of agreement. She's not going to agree to pay any other money. She's not going to agree to do anything else. She's also going to quit talking about it, right? Not only she turned over everything, not only has she turned over the rights, but she's going to quit talking about it. And she's going to quit going on TV shows and telling people. So again, PP agrees and warrants. PP agrees and warrants. PP agrees and warrants. These are all consideration that she is supposed to provide. These are legally enforceable promises. And if she breaches them, then she's in breach of the contract, right? PP agrees and warrants that there's no other texts. She agrees and warrants that she hasn't given copies of things to other people. She agrees and warrants that everything she said in here is truthful. Again and again and again, she agrees and warrants. She agrees and warrants. She agrees not to disclose. These are all enforceable promises. They are all consideration, okay? So could you list all of the consideration that Peggy Peterson is supposed to provide here? Sure, you could if you went item by item, line by line, and very carefully went over all 20 pages. But you better do it more than once because it gets complicated, and I promise you, you would miss something. I've missed it. I keep finding things. Like I said, I've been over this contract at least 2 or 3 dozen times. So can we summarize what she was supposed to do? Yeah. She was supposed to keep her mouth shut and stop talking about this relationship. She was supposed to collect all evidence she had of this relationship and turn it over to Donald Trump. She was supposed to then transfer to him any intellectual property rights she might have in the rights to a story, a book or a movie, those kind of things. And she was supposed to tell him about anybody else who might have evidence or information, right? In summary, those are the things she was supposed to do. Now, there's also releases. She was also supposed to release him so that she couldn't sue him in the future. And there were just a number of other things she agreed to. But this is, 15 or 20 pages worth of things that Peggy Peterson, aka Stephanie Clifford, aka Stormy Daniels, was supposed to provide as consideration. So let's back up. Was Peggy Peterson a party? Abso-freaking-lutely, right? She was going to get consideration. She was going to get $130,000 at least. We know that. She was going to give consideration. There's pages and pages and pages of consideration she was supposed to give here. So she's listed as a party. You can see at the end, she signed as a party, and she was supposed to both give and get consideration. So was Peggy Peterson a party? Absolutely. Okay. Next question gets even more complicated. Question number 5 is, state what consideration, if any, David Dennison was supposed to provide under this contract. Now, this is probably where the rubber meets the road. At the very beginning, they list David Dennison and or ECLLC as if David Dennison, as if Donald Trump may not even be a party to this contract. So how do we decide whether he's a party to the contract? Well, one way we could do that is to look and see, was he supposed to both give and receive consideration? Because if so, then he's a party, right? Now, if he was just going to get consideration and wasn't supposed to give any, is there any other possibility? Sure, we talked about third-party beneficiaries. Remember those? Like if I go to a car dealership and I buy a car for my daughter, I sign the contract, I pay for the car dealership is supposed to deliver the car to my daughter, who otherwise knows nothing about it. She wasn't involved. She's not a party, but she would be a third-party beneficiary. She has no obligations, but she might have a right to enforce it because she's an intended third-party beneficiary. But which one was Donald Trump? Was he an intended third-party beneficiary, or was he a party? And it turns out, we know he's going to get consideration because we just looked at all those things Peggy Peterson was supposed to do, and she wasn't supposed to give any of that to ECLLC. She was supposed to give all of it to Donald Trump. So he was definitely getting consideration, but was he giving consideration? Anybody got a thought on that? Put it in the text if you want to, if you don't want to speak up. I think that is an important question. I think it's the most important question in analyzing this contract. And I think the entire contract turns on it. And I think that the lawyers who drafted this were at least vaguely aware of that. But they didn't think it through. They didn't go back to their first principles and consider what it would mean if he did or did not give consideration. I think if you look at this contract, you'll see that they went to great lengths to make it look like Donald Trump was not supposed to give any consideration. At the very beginning, you may have thought that it was weird that EC LLC was in this contract. What was the purpose of that? Well, the purpose was so that they would be responsible for paying the money, not Donald Trump, right? If EC LLC is paying the money, then EC LLC is definitely a party to the contract. But if Donald Trump doesn't have to deliver any consideration, then it's at least arguable that he's not a party. And if he's very sensitive to people even knowing about this relationship, then he probably doesn't want to be a party, right? He doesn't want to have his fingerprints anywhere on this. He wants to be able to deny it and act like he had nothing to do with it. If it comes out, that was just something that somebody else negotiated. But was it true? They tried to make it look like he wasn't providing any consideration. But was that true? If you look carefully at this contract, if you have read it a couple of times, if you know what you're looking for, maybe now that I've tipped you off, I think that you will find that throughout this contract, there are little bits and pieces of consideration, of enforceable promises, of legally enforceable obligations that Donald Trump was supposed to give and was supposed to provide. Okay. Let's look down here at, well, back up here in 3, this section talks about the settlement terms. And then later we have some representations and warranties. And if you start looking at like where, at 4.3, representations and warranties and agreements by DD, right? Representations and warranties and agreements by DD. So DD is making the following agreements and warranties and enforceable promises, okay? How can he be a party, or I'm sorry, how can he not be a party if he is giving enforceable promises, right? We had intended third-party beneficiaries who are not parties to the contract. We've never talked about intended third-party obligors because there's no such thing. If you've got an obligation under a contract, you are a party. So this whole defining Donald Trump as and or DD doesn't do you any good because right here, A, representations and warranties and agreements by DD. B, DD warrants and represents, right? He's making enforceable promises. Now they're few and far between. There's a couple right there. Where else? We can look farther. They're hard to find. They're hard to find. They are well hidden, but there's more than that. If we look at 4.4, right? The parties to the agreement hereby agree. The parties. Well, that's DD too, right? He's a party to the agreement. And if the parties are agreeing to something, then that's another thing that he is agreeing to. That's further consideration that he's giving. There's other things like where are we? 5.2. Where is that? 5.2. They both agree that that if a dispute arises, then they both agree to submit to arbitration. Right? We talked about ADR, those alternative dispute resolution mechanisms. We talked about JAMS and the AAA, the American Arbitration Association. We talked about those were alternative ways to keep your case out of court and to keep them confidential. But in order to do that, the parties have to agree to it. They have to give up their rights to go to trial, and they have to give an enforceable promise that they agree to arbitrate. And the parties did so right here, DD and PP. That's yet more consideration. That's consideration that PP gave. It's also consideration that DD gave. They agreed to arbitration. Mutual releases. What are mutual releases? That's where both parties agreed to release the other. both parties agreed to give up their lawsuits against each other. Right here in 6.1, DD for himself agrees that he's releasing all of his claims against Peggy Peterson. That's an enforceable promise. If he's not making that, if he's making an enforceable promise, he has to be a party. He can't get away with making promises and not being a party to the contract. So, answer to question number 5, did DD give consideration? I hope at least some of you got that right, but I'm not calling any of you fools if you missed it, okay? Most of my students miss that. They say, no, only EC LLC was supposed to give consideration, right? The guys who drafted this contract were geniuses. And that's what the guys who drafted this contract thought. They thought, oh, we're going to have EC pay the money. And then Donald Trump's not really a party. We're geniuses because they didn't go back to their first principles. They didn't analyze this contract carefully, and they didn't realize that they just drafted in one after another promise that DD was supposed to be making, even if they tried to hide it very well. Okay. Now, question number 6 really just flips the answer to that question on its ear, or the last 2 questions really. Question number 6 asks, what consideration was Peggy Peterson supposed to receive, right? The consideration she was supposed to receive, that's easy, guys. We've talked about this now, right? It's easy. First of all, she was supposed to receive $130,000, right? We all know that's consideration. If somebody promised to pay you $130,000, you'd remember that one. She was certainly entitled to that, at least under this contract. That's part of the consideration she was supposed to receive. But she was also supposed to receive all of these other enforceable promises from Donald Trump that only Donald Trump could make, right? Only Donald Trump can obligate himself to these promises. Only Donald Trump can give away his rights to sue. Only Donald Trump can give away his right to a trial and agree to mediation or arbitration. I'm sorry. So what consideration was Peggy Peterson supposed to receive? Well, yes, she was supposed to receive $130,000, and almost all of you get that right. But she was also supposed to receive all of these other promises from Donald Trump, even if they're hard to find and even if they're hidden, okay? Now, I think that right there really starts to lead you to, is this an enforceable contract? Okay, the next question then, which now we've pretty much already talked about, is identify whether identify whether Donald Trump was a party or an intended third-party beneficiary to the contract, and explain, right? Well, I think I've already beat this one to death now. At the beginning, they tried to hide it. They tried to obfuscate, right? There's a legal word for you. Throw obfuscate in some of your conversations and see if your friends don't think you're showing off. Obfuscate just means to blur it, right? Or to make it unclear. They said that that David Dennison was and or a party. Maybe he's a party, maybe he's not. But what is the definition of a party? A party is someone who has both given and received consideration. They have privity. They're part of the negotiation, right? He was supposed to receive benefits under this contract. Okay. Parties receive benefits, but so do intended third-party beneficiaries. You're going to need more, Watson. Okay, I got more. He was also supposed to give consideration. Third-party beneficiaries are never required to give consideration. Contracts are never enforceable against third-party beneficiaries. They may be enforceable by third-party beneficiaries if they're intended third-party beneficiaries, but contracts are never enforceable against third-party beneficiaries. And if this was a valid contract, was Peggy Peterson supposed to have enforceable rights against Donald Trump? Well, it's not what people were expecting, right? But if she had kept her mouth shut, what if she had kept her mouth shut? He had lost the election, and then she decided to run for Senate next year, right? And as she was running for Senate, all of a sudden Donald Trump starts running around saying, hey, don't elect her. She had an affair with me. She had an affair with me while I was married. Would she have had a right under this agreement to sue him and tell him to shut up? I think absolutely so, right? He was supposed to keep it quiet too. Or what if she completely complied with this contract? What if she never said anything to anybody? She took her money, she gave him all the photos, and she went home to just, watch TV and stay silent. And then he sued her anyway. Would she have had rights under this agreement? Sure, because he signed those, because he was supposed to be giving releases. He was supposed to be releasing her from liability. He can't sue her once he releases her from liability if she complies with his contract. So was he supposed to be giving consideration? I think it's clear that he was. I don't know of anybody who can argue any differently. And that makes him a party, or at least he was supposed to be a party. All right. So question number 8, walking you through these, was please identify all of the parties that executed or failed to execute the contract. All right. Now that's not a trick question. You can scroll down here to the bottom, almost the bottom of the first agreement. Of course, there's that side agreement. And you can tell me who executed this agreement. Well, the handwriting's a little tough to read, maybe, but PP signed it, right? And in contrast to all this careful drafting they did to keep things confidential, she didn't sign it, Peggy Peterson. It looks like she signed it, Stephanie Clifford. So the cat's out of the bag, right? But it looks like Stephanie Clifford or Peggy Peterson executed the contract. It also looks like someone signed on behalf of EC LLC, right? Somebody signed on behalf of EC LLC. Who was that? I don't know. I can't make out the handwriting, but it looks like it was probably Michael Cohn. Why did he sign? Why did somebody sign on behalf of EC LLC? Well, because they're a company, right? They're a legal fiction. A company can't sign its own name. It can only act through agents, right? Remember, we talked about agency. And a company executes documents through their agents. Their agents execute on their behalf. And it looks like at least somebody purported to sign this document on behalf of EC LLC. So unless somebody is challenging that, it looks like Stephanie Clifford signed it. It looks like EC LLC signed it. But who didn't sign it? David Dennison. No signature, no date, no signature. All right. Now, there's a second page down here where Stephanie Clifford or Stormy Daniels' lawyer signed as well. And there's a spot down here where Michael Cohn signed as the attorney for EC LLC as well. And you'll see no attorney signed for Donald Trump either. All right. Let me be real clear what this page is. When it says as to form, that does not mean that the lawyers are signing this contract as agents. It doesn't mean that the lawyers are signing this contract as parties or to enter it. It just means that the attorneys are agreeing that this is the form of the contract that everybody agreed to, right? There's no extra pages. We didn't stick a bunch of extra stuff in. When lawyers sign as to form, it's just to confirm that this is the final document that we all agreed to. But even here, Donald Trump's representative didn't sign. Okay, so who are the parties that signed? EC LLC and Stephanie Clifford. Who are the parties who didn't sign? Donald Trump, right? Donald Trump didn't sign, or David Dennison, or whatever he wants us to call him in this contract. So what does that mean, right? That's the ultimate question here: is what does that mean? What if? Do you have to have a signed written contract in order for something to be enforceable? No, absolutely not, right? We talked about that near the beginning of the semester. We talked about that unless the statute of frauds applies, contracts do not have to be in writing in order to be enforceable. Handshake deals, oral contracts are enforceable. Even contracts where nothing was ever said, right? Implied contracts are enforceable. So you don't have to have a signed writing necessarily to be enforceable. But what do you have to have? Remember those other elements of contract? You have to be able to show an agreement. And maybe you could convince a jury differently, right? But I think that the generally accepted premise is that if parties are negotiating a contract and they write it up, that's still just negotiation. In fact that they wrote it up shows that they're not agreeing to anything until it's signed, right? The reason we draft a written contract, the reason we have signature lines is so that we know when it has been agreed to. Did Donald Trump agree to this contract? That's ultimately the question. Did he agree to be bound by this contract? If Stephanie Clifford took Donald Trump to court and tried to sue him over this contract, what would his very first defense be? Wouldn't his very first defense likely be, you can't enforce that contract against me. I never agreed. And you know how I can prove I never agreed? Because I never signed it. That's how you know I never agreed. If you can find a copy that I signed, well, then we'll talk. But I never signed it, and that means I never agreed to it. You can't enforce it against me, brother, right? Isn't that the way we normally view written contracts? Now, now, you could certainly argue with me on that point if you wanted to. If I was going to argue it the other way, I would say, well, maybe this is not our contract because he never signed it. But the parties began to perform, right? ECLLC paid the money. Stephanie Clifford accepted the money. Theoretically, Stephanie Clifford began to deliver those photos and texts and that kind of stuff that she was supposed to do. There was at least a beginning of performance by some parties, right? Stephanie Clifford partially performed, ECLLC partially performed, but that's still not enough to show an agreement by David Dennison, by Donald Trump. He didn't do anything. Everything he was supposed to do was either to make an enforceable promise or give up a legal right. And the only way he could do that is either by signing this agreement, by entering into an agreement, or by getting sued later and then saying, no, I gave that up, right? He didn't sign. And so I think it's clear that he did not agree. All right. Which then brings us back around to, we already answered the question, if David Dennison, what was David Dennison supposed to give consideration, right? Or what consideration was he supposed to give? He was supposed to keep it confidential. He was supposed to release claims. He was supposed to hold Stormy Daniel harmless, not sue her over any of this. He was supposed to agree to arbitration. He was supposed to give up his right to trial and agree to arbitration if this ever turned into a lawsuit. So that's consideration he was supposed to give. But the question is, did he give it? If he never gave it, if he never agreed, then he never gave any of this, did he? He didn't actually pay any money. He didn't actually do anything. And that gets us to the next one. If he didn't provide the consideration that was anticipated under this contract, then did Stephanie Clifford get everything that she contracted for? And I think the answer is clearly no, right? Sure, the main part was she was going to get $130,000. And she did receive that. She at least received part of it. But she didn't receive everything she was supposed to receive under this contract because Donald Trump never agreed. And in my terminology, in the terminology we would use at the courthouse, I think that would make that would mean that this contract is still executory, right? It has still yet to be agreed to. It is yet to be finalized. Okay, maybe the parties started operating under it, but it has yet to be finalized. As a result, I don't think that this contract is enforceable against Donald Trump. He didn't agree to it. He didn't sign it. And if it's not enforceable against him, then Stephanie Clifford didn't get all of the things that she offered to agree to. And if she didn't get her part of the deal, then this contract is not enforceable. Is there anything anybody can do? Sure, I suppose ECLLC can come back and say, well, if this contract never made, then give me my money back, right? They're probably entitled to their money back. But the contract as it's written, I don't believe is enforceable because Donald Trump, as this contract was written, was supposed to be a party. He was supposed to give consideration to Stephanie Clifford. He never signed it. He never agreed to it, which means she never got everything she was entitled to. Okay. And as a result, it's not enforceable. All right. At least that's my opinion. Now, again, people at least didn't lose their bar license over arguing the opposite side. But I think 9 times out of 10, if you get an honest attorney, or if it involved other people that maybe weren't quite so political, I think that's the analysis you're going to get. And I think that if any of you had been working for Michael Cohn or for Stephanie Clifford's attorney, you could have suggested, hey, this looks a little weird. If Donald Trump hasn't signed this yet, do we really have an enforceable contract? And if they said, oh yeah, we thought about that, we're way too cute. We're cute times 2. We said and or Donald Trump in the party section, right? So ha ha ha, it's enforceable even if he doesn't sign. I hope some of you could have said, well, but wait a minute, he's supposed to be giving consideration. And if he doesn't actually give that consideration, then one of 2 things: either he's breached the contract, or he's not even a party to the contract and she didn't get everything she was entitled to, right? So my very last question is, okay, assuming I'm right, assuming this contract is not enforceable, you guys are bright enough now. If you thought about it long enough, especially after the conversation we've just had, I'll bet some of you can think of a way that we could have made this enforceable. It's what the original lawyers were trying to do. They just didn't succeed. But do any of you want to show off? Any of you got ideas of what we could have done to make this enforceable? For me, the answer is pretty clear. The answer is, if you had just gone through carefully and read this agreement, if you had gone through carefully and struck out any possible obligations by Donald Trump, okay, so everywhere where it said DD represents and warrants, got to strike all those out. Anywhere where it says the parties agree, got to strike those out, right? And you probably better take his name out of the section that defines him as a party, all right? But if they had quit trying to be so clever, they could have entered into a perfectly enforceable agreement between EC LLC and Peggy Peterson for Donald Trump's benefit. That they could have done that, just like I could buy a car for my daughter and she's not a party to the contract. All right. If EC LLC had paid the money, and in exchange, Peggy Peterson had promised EC LLC that she wouldn't talk about Donald Trump and she'd burn all the pictures, then I think not only would that have been enforceable by EC LLC, but it would have been crystal clear that Donald Trump was supposed to be, it was an intended third-party beneficiary, right? Who else could possibly have benefited from that contract besides Donald Trump? And if he had zero obligations, it just might have been enforceable, all right? But that is not what they did. And as a result, they tried to draft something to be cute and to keep and to hush this alleged relationship between Donald Trump and Stormy Daniels, and they just made it worse. What ended up happening with this contract is that then gave Stephanie Clifford the perfectly valid option to run down to a court in California and to file what we call a declaratory judgment action. She filed a lawsuit for the court to declare that this contract was invalid, okay? Because he didn't sign it, right? Easy. Is she, I mean, is it a lead pipe cinch? Are we sure she's going to win? I don't know, maybe not. Maybe there's some argument they could come with, but it's at least a perfectly valid claim. Why? Because he'd been threatening to sue her over the contract. And she said, not enforceable. Watch this, Donald. I'm going to go down and file this confidentiality agreement in the public record where everybody can see it. Where do you think my smartass got a copy of it? I just went down and pulled it off the clerk's website, right? And they were very crafty to black out Donald Trump's name But everybody in the entire world knew exactly what this contract was about. And they litigated over this contract for months and months and months, which just made it even worse. People were still talking about it, and it was still in the news, and it gave people to chew on and to bring back up. Hey, what's the latest in that lawsuit between the porn star and the presidential candidate, right? They just kept talking about it because they didn't draft a good contract, because they weren't good contract lawyers, because they didn't go back to their first principles and remember the 4 elements of a good contract. They made this very, very complicated, very, very obscure, and it just didn't need to be in order to be effective. Okay. Anybody got any questions about that? If I've still got you with me, let me point out 1 or 2 other things in this agreement, just because we talked about them in this chapter or a chapter before, and because they're relevant. Let me take you to page 9. All right, remember these? We talked about what is a liquidated damages clause. We talked about that a week or 2 ago. A liquidated damages clause. Remember, that's where if the parties decide ahead of time that, hey, if there's a breach of this contract, we may not be able to determine what the actual damages are, right? This is a great example of that. If Stormy Daniels goes off shooting her mouth off and telling everybody she had an affair with Donald Trump, how would we measure his damages in dollars and cents? It'd be really hard, right? And so the parties agreed ahead of time to a liquidated damages clause. We talked about those. And here's an example of one, right? There's one right there. We also talked about when are liquidated damages clauses enforceable and when are they not? Do you remember when they are or are not enforceable? They are enforceable when they look like a reasonable attempt by the parties to estimate what might be hard to prove damages, right? When are they not enforceable? They're not enforceable when they are purely punitive in nature. Let's look at this one. What did it say? First of all, it only applies to Peggy Peterson. It doesn't apply to Donald Trump, right? Big red flag right away. But second, it says that she will agree to pay $1 million, right? $1 million for each breach, every time she breaches. What happened? In the first weekend this came out, her lawyer went on MSNBC and CNN and any other place that would have him, and he told about 15 different news outlets about this agreement. And as a result, Donald Trump's lawyers sent a cease and desist a letter to Stephanie Clifford and claimed that she was already liable to them for something like $34 million. Every time her lawyer mentioned Donald Trump's name, they said that's another million, right? Really? She got $130,000 for this contract. Do you think it's reasonable for her to then be liable for $34 million if she breaches it? Is she ever going to be able to pay $34 million? Is that a reasonable reflection of Donald Trump's possible damages? Or was it just meant to be punitive? Was it just meant to scare her to death so that she would never dare breach this agreement by opening her mouth, right? I think there the answer is pretty clear. I think any court in the world would have found that that was merely punitive and therefore unenforceable, all right? There are a couple of other paragraphs I'll just point out real quick because I don't want to waste your time. I thank those couple of you for being here. I want to respect that. But let me show you section 8.1, right? 8.1, the entire agreement. Does anybody remember what that is? That's what we would call an integration clause, And do you remember why that's important? Because we had that parole evidence rule that said, if you have an integrated contract, a contract that is meant to be the entire agreement between the parties, then the court won't allow any outside testimony to change or alter the terms of the contract, right? If it's an integrated agreement, then we're going to assume that the words on the paper mean what they mean. And we're not going to accept outside testimony to change those terms, right? And to be clear that this was meant to be that type of agreement, they put in an integration clause, right? And that's what that is right there. 8.1 is an integration clause. And that's what they sometimes look like. That's not a particularly well worded one. And it kind of rambles on, but that's what it is. And that's why it's there. See, you did learn something about contracts, and there's an example of it. We also talked a little bit about choice of law, that choice of law is different from jurisdiction, right? That you couldn't create jurisdiction. If a case doesn't have anything to do with Texas, then the Texas courts can't hear the case. But just because the Texas courts hear the case doesn't mean they have to apply Texas law. What if one party is in Texas and one party is in Nevada? Which law applies? Well, the parties have a right to contract over that, right? And they did that here. We have a choice of law provision. And it actually gave the election to Donald Trump right here, DD. At DD's election, well, I can't get this to highlight. At DD's election, he can choose either California or Nevada or Arizona law, right? He gets to pick. Is that enforceable? I don't know, probably, because normally choice of law provisions are enforceable as long as they're moderately reasonable. And we have every reason to believe that Donald Trump has some connections with Nevada. We know he has some connections with California. Why did they pick Arizona? I got no idea. That's probably where Stephanie Clifford was living at the time. One last provision I'll point out, and then I'll see if you guys have any questions, and otherwise I'll let you go. Do you remember we talked about attorney's fees? We talked about that in general, the American rule, the quote American rule, is that every party pays their own attorney's fees. We also talked about that there is oftentimes an exception to that rule for contracts, but that you have to be careful because each state may be a little bit different, right? For instance, in Texas, only a successful plaintiff trying to enforce a contract gets to win their attorney's fees. A successful defendant who defends a contract does not get their attorney's fees, at least under Texas law. But we talked about that the parties are always free to amend that, and they did that here, right? You could amend that by saying whoever the winning party is gets their attorney fees. That's one way they could have done it, but instead they went the other way. They said that regardless of whether or not there's an exception, every party will pay their own attorney's fees. I'm sorry, I told you I was only going to do one, and then I'm actually going to do two more. Last one, 8.6. And the reason I didn't start to point that out is because this is not a good example. We talked about one more rule of construction this week. Well, we talked about several other, but one more I want to point out. We talked about the rule that if there are ambiguities in a contract, it will those ambiguities will be interpreted against the party that drafted the contract, right? And so a lot of times to get around that, you don't want it interpreted against your client. You don't want the court to think, well, you're the one who drafted it, so you're responsible when you feel like both parties agreed. And so there's not a very good example of one of these clauses because, again, these weren't contract lawyers and they certainly weren't trial lawyers. But this is one of those sections where they try to set out that both of the parties were involved in negotiating this contract and both of the parties had counsel. And the point of that is so that when they get to trial, if they get to trial, one of them doesn't get whacked with that presumption that because you drafted it, if there's an ambiguity, we're going to interpret it against you. All right. Again, they did not do a good job drafting that. If you ever need to draft a contract and you want to put that clause in, do not copy the one out of this agreement. But at least you can see in general, that's why they put those things in there. Okay. Ladies, thank you for being here. I wish we had been able to do this live because it's always much more fun. I can shame you all into speaking up and asking questions when we do it live. But you did show up, and so I'm certainly not going to shame you here tonight and unmute all your microphones to see what you're talking about. If you have any questions about that, please ask, because this was a terribly complicated, unnecessarily complicated contract. But I hope it was at least marginally interesting to you. And even if you did the assignment first and you were like, I don't get it, I don't know what the hell Watson's talking about, I hope now that we've gone through it, you've started to see how some of the stuff we've been talking about all semester actually works, that will maybe start to crystallize some of that knowledge. I will tell you, I have had several students come back after the fact because they didn't really participate in the discussion, but later they wanted to talk about it more. Even another semester or two later, they've come back and now it's been gnawing at them and they want to talk about it some more. I even have one student who got a job because of this contract and because of this assignment. He was talking to a lawyer at a convention or something. The guy was not hiring, but the guy asked him, well, did he learn anything interesting in school? He started talking about this. He started explaining to this lawyer why he didn't think that settlement agreement with Stormy Daniels was enforceable. And the lawyer thought about it, went back to his office, looked up the contract himself, and then called the guy and offered him a job. Okay. So if you can explain this contract, even kind of, if you can explain this contract to somebody, then you did learn some contract law this year. All right. Any questions?
I don't really have any questions, but I will say it's been nice to hear you explain it live like this, because I think a lot of the time I end up overanalyzing or trying to look for the answers and making it way more difficult than how it can be.
Me too. Me too. And it's always tempting to do that. And in fact, that's what happened to the lawyers here. They just kept getting too tempted and they kept seeing too many possibilities and they kept trying to analyze them in the way that they knew. And they screwed up. My advice in law all the time is always go back to first principles, keep it as simple as you can. Okay. And I hope maybe one day that you're so bored that you actually decide to look through another contract. I hope you look through this one again. If you're a Donald Trump hater, pull it out and just revel in the fact that, this is a terrible contract. And if you're a Donald Trump lover, then look over this contract and think of a perfectly good argument why you think it's enforceable. Call me back one day, come to my class and shout, call me out, show my other students why I'm wrong. But it is a great example of, I think, that you can go through and you can try to apply some of these concepts that you've learned. And remember, so often law is not black and white until the judge makes a decision. Both sides got their own argument, and who's going to win? It's the person who understands the principles best, who can explain them best and explain to the judge why this gray, mushy, abstract, poorly drafted contract really means this crystal clear principle that we learned in contracts class or in law school or wherever. Okay. Any other questions? If you don't have to ask them tonight. You can always call me or email me anytime. Otherwise, you got a couple assignments this week. They ought to be pretty easy. If you've now listened to this, you do not have to write up 75 pages worth of stuff to get this assignment right. I'm perfectly happy if you go back and answer this assignment after we've talked about it, because if you can kind of answer it right now, then it means you learned something and it means you got something out of this assignment. Otherwise, we've got a short chapter and just a few things to do next week, and then a final exam. And so I'm going to post this recording tonight so that everybody who wasn't here can see it, and then they can fake their way through their homework. But I will also post a review for your final exam, and we'll talk about that later. Your final exam will be comprehensive, but really because that's the only way to do contracts law. If you can't make the first step, then the third step doesn't matter. But it'll look a lot like your midterm. If you did okay on your midterm, then you know what to expect. And if you didn't do okay on the midterm, it's because you didn't look at the review. If you looked at the review, I can see who looked at it, and everybody who looked at it did just fine and aced it. And I'll put up a review for the review for the first half and the review for the second half. But if that's not enough, you call me, you email me anytime. Okay, that's what I'm here for. Or I was going to say, come to my class. I don't have a live contracts class this semester, but I do have a live civil lit class. You guys are always welcome to come to that one. It's on Monday nights. But if you've got questions and you just can't get them answered any other way, call me, email me, text me. You've got my number, or come to my civil lit class on Monday night. All right. That's it. Anybody got any questions? I'll wait around here as long as you want to. Otherwise, I expect people to start clicking out and bailing out just as fast as they can to get to dinner. But I really do appreciate y'all being here. At least I got a chance to see the faces of a few of you, and the other 46 or something, they'll just be names on a page to me.
All right. Thank you.
Thank you.
Y'all have a good night. Thank you so much.
Professor Watson.
Thank you.
Thank you all for being here, sincerely.
I have a question.
Yes, ma'am, shoot.
On the, are you finished grading some of the assignments? I now have maybe one or two that hasn't been graded from October.
You may have more than that are not graded.
Okay.
I had 2 trials last week and a trial this week.
Okay.
It was supposed to start Tuesday and I just finished it up this afternoon.
Oh, okay.
But I finished my trial today and I'm still alive. And so I will dive into grading stuff tomorrow. And I'm going to write down Sheila Glenn. In fact, I'm going to turn off the recording first.
Okay.